Ramaphosa's advocate, Wim Trengove, SC, told the High Court in Pretoria yesterday the documents were made available to the EFF and other respondents, but they never incorporated the documents into their main case. The EFF is applying to unseal the CR17 bank statements. Julius Malema is adamant South Africans have a right to know who funded Cyril Ramaphosa's ANC presidential campaign and whether his donors are benefiting from state contracts. Trengove has argued the documents are private information and are therefore constitutionally protected. Trengove reminded the court a full bench of judges ruled the public protector's investigation into the CR17 campaign was unlawful. And of course, that is linked to our poll for the day at the agenda_SABC. Have that conversation with us. But today's processes with regard to that case are on, and let's take you there now. President Cyril Ramaphosa's advocate, Wim Trengove, and I think he's on the stand, but let's take you there live.
Ever reads in the following manner. If the center in the performance of its functions has a reasonable grounds to suspect that an accountable institution, in this instance the PP, the public protector, or any other person other than a supervisory body who is subject to the provisions of this act has contravened or failed to comply with any provision of this act, or any rule or guideline applicable to that accountable institution or person which facilitates compliance with this act, it may, if it considers it appropriate to do so, refer the matter to a relevant investigating authority. That's what they must do in the event that they are minded to think that there has been non-compliance. B, or make an appropriate supervisory body or other public body or authority affected by it, together with any recommendation the center considers appropriate. So what the statute does there is, if you are complaining that the public protector has handled the information incorrectly, the act then says to the FIC, this is what you do. You refer the matter to a relevant investigating authority. What it doesn't say is that you interpose yourself in litigation, civil litigation, everywhere that information is discussed, which is what they are doing in this instance. So my learned colleague then says the question is, do we attack the FIC Act? No, we don't. And we don't intend to attack the FIC Act at all. What we are saying is, Section 44 is that type of remedy that is available if the contention is that there are contraventions relating to the confidentiality of the information that it holds. Now, we make the point, the reason one suspects that the FIC has not acted as Section 44 dictates is that it knows that the immediate response by the public protector, why it dispatched the record, why she dispatched the record the way she did, it is because she was required to do that in terms of Rule 53. Those would be the submissions in relation to the reply to the submissions, but before I close that element, I must go back again to the first respondent who says that the remedy that the applicant has in this instance was to go to the PI Act and request the information in terms of PIA. Well, one, that is not the election we make, and two, it misses the point that this application is also made in relation to Joe Public, who is out there, who has the right to the Rule 53 record, who can access it without doing a PIA application. So what the first respondent's argument does there is to set up a schedule and then drop it. We are not accepting that schedule as a basis of the approach the applicant is taking in prosecuting this claim. Regarding the question of cost, my Lord, we make the point. This application, your Lordship would recall, is being brought also in terms of Section 38 because it is intended to assert that right of Joe Public, who is saying there are matters that are lying with the registrars and a court record that affect matters of public interest that I'm interested in, and now they are under the seal of the Deputy Judge President. I need access to them. I need to inform myself whether or not this government is holding true to its constitutional obligations to conduct itself as a democratic country. And that is why that the 38 claim is made. But we also made the claim that the application is brought under Section 19(1)(c), in particular, of the Constitution. Now, we say if we are successful, the costs should follow the result, because the first respondent, your Lordship would recall, when we cited him in his personal capacity, there was protestation that no, he wants to be cited in an official capacity. So they introduced the vertical relationship there. But even if the relationship were horizontal, we make the point that because of the nature of the subject, the BioWatch principle would apply. That, my Lord, would be the reply we have to the arguments submitted on behalf of the various respondents.
Thank you, Mr. Are there any other replies? It doesn't appear that there are any other replies. Very well, I think we are at the end of the session, unless parties have any other issue that you want to raise. If not, I will reserve judgment in the matter and hand down judgment in due course. I must thank all the council for the very useful discourse that we've had. It certainly is of great public interest, and we must ensure that what is expected in these matters happens. But once again, thank you for your input and your submissions. The court will adjourn.
As the court.
Well, there you heard it. Court has just been adjourned. Judgment has been reserved, will be given in due course. Of course, the process ending there with EFF Counsel Ismail Sebenya SC putting forward his responses and arguments for his client as to why the CR17 bank statements have to be unsealed. Let's try and look at some of the responses you've sent through in terms of our poll today that we have been running, asking you if the statements should be unsealed. 75.2% of you say yes, they should be. 24.8% saying no, they shouldn't be unsealed. And I don't know, from our production team, let's check if we're getting some of the comments. Of course, that's as you heard from the court processes. There is a huge public interest in this conversation with very strong points coming from both sides. Let's take a look at the tweets. Today and tomorrow says, are we going to be shown original or doctored statements? Extra small saying, is there something to hide? Andrew Matthew Stevenson says all political parties should be transparent and disclose their bank records. Nazim says yes, they should be unsealed, and I want to who's who in those records so I can make my own judgments. Welile says they must be unsealed, full stop. I don't care about the funders. I want to see who received payments. If judges really got bribed, then the country needs to know. Crow says yes, the clear confusion and deal with corruption. Transparency is the core value of a democracy. Government should be subjected to public scrutiny. Why such a question really? That's from Comrade 5 September. Concord says if Ramaphosa was an honest and transparent person he pretends to be, we wouldn't be asking this question. We would have long opened up his campaign for scrutiny. He's now acting like Donald Trump, who refused to disclose his taxes. The sad thing is that the courts are part of this. I don't think you can compare though, but that's your point. Malefetsani says, I don't see need as to who funded who due to some companies or individuals believing in privacy for not to be known. Secondly, if it was recorded that any political funder should disclose, then it was supposed to happen. Kagiso Munyadiwa says, what is it that Cyril Ramaphosa is hiding? We're not interested in people's account numbers and details, but we're interested on names of his campaign sponsors so that we can check if they are benefiting from the government anyhow. We want to know if there's capture or not. That's all. Kagiso, I imagine the EFF would agree with you on that point. 515 people have voted on this poll already, where we're asking you, should the CR17 bank statements be unsealed? Continue to interact with us on this conversation. Let's take a break for now.